Welcome back again viewers to TELECOMRECORD Entertainment Immigration Updates. In this video I will discuss the process in applying for a United States Provisional Waiver, I-601A, step by step. There are many reasons why an immigrant is considered inadmissible to the U.S. One of those reasons is illegal presence in the country. An immigrant is considered to be unlawfully present if they have overstayed their valid visa, arrived without inspection, or violated a temporary visa status. Although illegal presence can be a bar to admission into the U.S., help is available to overcome this issue. By filing for an I-601A waiver, also known as a provisional waiver, you may be able to continue processing your immigration case even if you were illegally present in the country. In order to file an application for provisional waiver, you must have an approved I-130 petition and must have paid the immigrant visa fee. If you don't have an approved I-130 petition, then the first step is to file a Form I-130, Petition for Alien Relative. USCIS will normally take between 3 to 6 months to process the I-130, although recently it has taken longer than usual. Please note that these are only estimated processing times and no attorney can guarantee that your case will be processed sooner. Once the I-130 has been approved, it is forwarded to the National Visa Center, NVC, for the immigrant visa process. This part of the process involves 1. Notifying the NVC that you plan on filing Form I-601A, 2. Paying the immigrant visa and affidavit of support fees, 3. Completing the immigrant visa application, DS-260, and 4. Submitting all necessary documents to the National Visa Center for processing. This part of the process can take as little as 2 months. Once you have paid the immigrant visa fee, you can proceed to file Form I-601A, application for provisional waiver, with USCIS. USCIS will then notify the NVC that you have filed the provisional waiver application and the NVC will place the file on hold until a decision is made. You can visit USCIS website link on provisional waiver for more information on what is required for this step. The estimated processing time for the I-601A is between 4 to 6 months. If your application is approved, USCIS will then send notice of the approval to the National Visa Center. What is an I-601A waiver? An I-601A provisional waiver allows certain immigrants to request a waiver of their unlawful presence. This includes qualifying relatives, spouses and children, of U.S. citizens or permanent residents. In 2016, the process was expanded to all individuals statutorily eligible for an immigrant visa, and a waiver of inadmissibility for unlawful presence in the United States. Normally, an applicant over the age of 18 who has overstayed in the U.S. for 180 days or more, but less than 365 days, is barred from returning to the U.S. for 3 years. An applicant who has overstayed for more than a year can be barred for 10 years. In some cases, such as trying to re-enter the U.S. after having accrued more than 1 year of unlawful presence, the bar may even be permanent. Unlawful presence can have lengthy and serious consequences. It can result in being barred from returning to the U.S. during your consular interview. However, an I-601A form may allow you to apply for a waiver of the unlawful presence bar before needing to leave the U.S. This process allows an applicant to apply for a provisional waiver before they leave the U.S. for their consular interview abroad. The reason behind the waiver process is to promote reunification of family members, as well as to shorten the time that families must be separated while their relatives are obtaining immigrant visas to become lawful permanent residents of the United States. If the National Visa Center has already completed the immigrant visa process, then it will place your file in the scheduling system so that an appointment is scheduled at the appropriate U.S. consulate. Appointments are normally scheduled after 2 to 3 months. How can an immigration attorney help you? A qualified and knowledgeable immigration attorney can help navigate the I-601A waiver process and provide invaluable legal and technical advice. They can help you fill out the required forms, obtain the necessary evidence and documentation, and ensure your filings meet all rules and requirements. Because the provisional waiver process can be complex, retaining an immigration attorney can help simplify and resolve some of the major legal and technical issues. If you find this information informative and helpful, please don't forget to like, comment, share, subscribe and donate to this channel. Links are provided in description below.